Good evening, this is John Milburn for Laws 12067. This is Environmental Law and this is Term 3, 2019. Well, thank you all for joining me for the live session. And for those of you watching as a recorded session, a recording of this session, please do consider joining us for the live session on Tuesday evenings at 7 p.m. Just watch for the holidays this term. We have 2 breaks. And one of those is in between weeks 4 and 5, and the other, I believe, is between weeks 6 and 7. So I've identified the dates on Moodle, so please keep an eye out for that. Environmental law, extremely important. There is a strong scientific imperative to act on climate change. The overwhelming weight of scientific evidence confirms that climate change is real, that it is caused by the release of greenhouse gases, and that human activities are the primary cause of global warming. Unmitigated climate change will potentially have catastrophic impact on Australia's natural and built environments. That's from Jerry Bates. Introduction to Chapter 10 of the 10th edition of the text, the edition that came out this year, and that's at 10.2. An extract from the earlier edition, the 9th edition of Bates. Unless protection of biodiversity is linked with planning and development, then the regulatory authorities responsible for biodiversity management and protection are simply fighting a losing battle. Jerry Bates, 9th edition, at 14.93. So there are a couple of quotes that resonate strongly, particularly given the weather conditions that we're currently experiencing. The task that I have in teaching environmental law is twofold. The first is that it's a unit that's offered only every second year. So there is a considerable amount of new material between the times that I offer the unit. And I think this is my 4th time in offering, so I've been doing this since 2014 or 2015. So it's a real privilege for me. And the other thing, of course, is that the material does change considerably, and the way in which we teach changes from one year to the next. So 2 years is a long time in university life. It's a pleasure to see some familiar names on Moodle. Thank you for joining us. And if you've worked with me in the past, you know that I do value interaction. I previously used a thing called uCrew, which was kind of like Facebook. I'm not a Facebook person, so I don't have a Facebook page for this unit. But if you are, and you feel the need to do so, please set one up, but I won't set one up for you. So for me, interaction will be through Moodle. You can certainly email me, but I'd encourage you to try to have the communication between all of the class so that we can exchange ideas, and please contribute. So don't feel that everything needs to come from me. I'm sure that many of you come to this unit with a wealth of experience. We're in an advanced subject now, an elective, so many of you really do know the ropes, so to speak. So please feel free to contribute, and I look forward to doing so. If you haven't worked with me in the past, you may not know that I'm a barrister. I'm also a member of a couple of tribunals, and of course I've had the privilege of being a university lecturer and course coordinator here since I think 2011. The focus of the unit, as is the case for all of the units that I take, will be towards practice. The focus will be those who wish to practice in this area of law, or alternatively work with people that do practice in this area of law. You'll see that over the years I've introduced videos primarily from people within the industry. So there's videos from district court judges, QCs, environmental activists, lawyers that are involved in different aspects of environmental law, etc. So if any of you do wish to appear as a guest on the lectures, please let me know and I'll be happy to interview you and we'll upload it. And I have had one instance where a current student was a guest lecturer, and that was in the planning and environment sphere because that was his specialty. So if you have any particular specialty, then please feel free to advance yourself as a person who might be a guest lecturer. If you know of anyone that would be interesting and would like to join us in a live session, or at least me perhaps in an interview, again, please let me know. So it's a very practically orientated unit. As always, we need to look at a few basics, such as we'll start with the textbook and the supplementary text. So from the unit profile, you'll see that the textbook is Environmental Law in Australia, 10th edition this year, and I've referred to it already. The supplementary is Planning in Queensland. This is Philippa, England, and it's a very good textbook. This is a brand new edition. I previously prescribed this a number of years ago, but now it's right up to date. So it's there as as a supplementary text. Some of you, and David, thank you very much for your communication today, have alerted me to the fact that the University Bookshop is stocking apparently the 9th edition. Now, it is quite clear that in about September, I said we've got a 10th edition. So if anyone from the University Bookshop is watching this video, please let's see if we can do something about updating the material that we have for sale for the students. And it may be that students will need to access the 10th edition elsewhere. That said, Bates is a very expensive textbook. It's very good. It's highly authoritative. But if you find that you are working from a 9th edition or even an 8th edition, you can still get through the unit. It's going to be more difficult, and certainly working off the current edition would be preferred. So on Moodle, you would have seen a unit outline which serves a number of purposes. Hopefully it's on the screen now. And the unit outline provides an indication of the weekly topics, which is replicated in Moodle, and then reference to the 8th, the 9th and the 10th edition of the textbook with the relevant chapter to the unit for the week. So for example, if we look at week 7, environmental impact assessment, if you're working off the 8th edition, read chapter 10. If you're working off the 9th edition, chapter 11. And if you're working off the preferred current edition, then read chapter 5. And you'll see in the far right column, there's reference to the problems that are uploaded in Moodle that I'd like you to consider and answer each week. Any questions then about the unit profile or unit outline, the unit profile or the textbooks that we need to consider? All good? Now, Karen, Emma and David were talking about Zucal. I don't know, or Jekyll is another place. These are sources I'm not familiar with. Anyone wish to share some information? Yes, Karen.
So I usually check the university prices first, and then I go to Zucal. And in this case, when I checked, the university didn't have the supplementary textbook available.
Yes.
So I got both at Zucal. The main textbook was, I can't remember now, about $20 or $25 cheaper, and it's free postage.
Wow.
And they deliver quite quickly within a week.
Okay, great. So that was Zucal. Thank you.
I
Yes, David.
use Jekyll as well, which is an offshoot of Zucal. I think they own it, and I ordered my text on Tuesday, and it was here on the Thursday.
Oh, excellent.
It
Oh,
was
thank you,
very
Lois.
fast, and it was, yeah, again, it was cheap, and it had free postage at the moment too.
All right. And did you say that was Jekyll?
That was Jekyll, yeah, but they're owned by Zucal, so
Okay.
I think it's much of a muchness there.
Thank you. And David, you've sourced through Zucal as well.
I reluctantly went to the CQU bookshop to get these textbooks as well for another subject, but I was in a bit of a hurry, so I decided to order through them because they said they could do all at the same time. So I got the supplementary, but they had none of the environment law book, which I discovered was the wrong edition that they had listed on their website. So I ended up going to Zookle, and I know that they've got over 50 copies in stock as we speak, and they are significantly cheaper than CQU, which as I said, I reluctantly used, but I had to because I was in a bit of a hurry this time, and they still stuffed me around, in other words. Yeah.
All right, thank you very much. And Jamie Lee got hers from Booktopia. So a range of sources and opportunities to obtain that textbook. All right, so thank you very much. Now, the next thing, of course, is that if you've worked with me previously, you know that I want you to work backwards. That means always considering the take-home paper. We do that as from this week, and we consider the assessments this week. So again, sharing the screen. I trust that those of you that are joining this session tonight and those of you watching this as a recorded session would have spent a considerable time already in looking at the Moodle site, looking at the assessment work and mapping out your study plan. If you haven't, please do so now. It's very important that you stay ahead of the game. Generally, with my assessment work, it's due on a Thursday evening, 11:45 p.m. And generally with my assessment work, there's a cut-off, which is about 9 or so days after the day it's due. So essentially, you have 9 days before I will stop receiving assessment work. If you're late, then you lose 5% per day for each day of late submission. And if you find that you can't submit on time, you're welcome to apply for an extension. You do that before the date is due. However, you'll understand that having released the specific questions on the first day of term, it's very difficult for me to justify an extension application if you say, well, I ran out of time, or I had a cold on the last day, or something went wrong. So the moral of the story is, please work ahead, work diligently towards having something prepared before the assessment is due, so that you'd have 95% of the assessment work done a couple of days before the assessment is due, just in case something goes wrong. Either that, or you've actually uploaded the assessment work. Now, with the take-home paper, I guess generally one of the best ways to prepare is to look at past papers. One of the problems, of course, in having this unit every 2 years rather than every year or multiple times during a year, as is the case with some units, is that the most recent paper was 2017. Have you looked at that paper on Moodle? Yes, there's a few yeses. Anyone got any, did anyone notice something unusual about that paper? Not yet. So I'll just share the screen. We'll have a look at that paper from 2017. And you'll see it was the take-home paper. What's unusual is that it was released on the 9th of February at 5 p.m, Friday evening, and it was due on the 9th of February at 8 p.m. So it was a take-home paper, and I generously allowed students 3 hours. Now, I'm not going to do that to you. This time, I'm releasing it on Thursday, the 13th of February, 6:45 p.m, and it's due on Friday, the 14th of February, 11:45 p.m. So you have considerably longer in order to complete the task. The warning then is that you would expect a take-home paper considerably more difficult than the paper that I set 2 years ago, knowing that students had a mere 3 hours to complete the task. So I'd recommend, if you haven't already done so, look at that paper, get a feel for it, and it's just really examining one aspect of environmental law. But you'll see that the task that I provide is typical of the tasks that I provide in other units, where it has that practical orientation. When it comes to assessment work in environmental law, there are just a limited number of protagonists or antagonists, depending on your perspective. So just to get you into the mood and thinking about it, assuming that I'm going to ask you to prepare a response from the perspective of someone who has an interest in an environmental law dispute, let's say, who are the people that are involved in environmental law litigation, just generally? Any thoughts? Unmute or use chat. So if the question is from the provide advice to somebody, who's the somebody?
It could be a company that's been accused of illegal dumping or violating some environmental laws.
Excellent, Karen. Yes. So it may be that it relates to some sort of criminal law activity or quasi-criminal law. It might be regulatory in nature, and it might be a company, exactly, that is accused of some environmental crime or wrongdoing. Excellent. Jamie Lee has a good one here, local government. Certainly local government have a part to play and adds to that company or person. So from what perspective do local governments become involved in environmental law and practice? Any thoughts?
I was going to say also on a state level, you have major infrastructure projects that can impact local environment and community.
Absolutely. Yes, state government have a role to play, a considerable role to play. So it may be that the task that I ask of you is to provide advice from the perspective of the local council or the state government. And some of the other comments coming through are, Emma says councils, organisations and residents. So Emma, we've talked about councils. Organisations could be wide-ranging. Feel free to unmute you if you wish. And residents may be those people that have an interest in environmental law activities. Now, of course, does anyone know what we mean by the term standing? Standing, has anyone heard of that in the context of going to court and suing? There's a
But you have legal standing, you have a basis, you have a legitimate claim to take something through the court process.
Correct. Thanks, David. And Michael said, yes, if you have the right to be in court. Jamie Lou says, if you have the standing to be there. So standing is relevant in the context of environmental law practice because we need to overcome that basic hurdle, that dreaded question when someone as a community litigant stands before a court and the court says, well, I understand that you have some concerns and you wish me to do something about an environmental activity. But what right have you got to be here? What's your standing? What's your entitlement to present something to the court and ask for an order? So keep that in mind. But Emma's right. It may be that the question I ask of you is to provide advice from the perspective of a council or an organisation or residents. Jamie Lee says local government, company person, and it may relate to enforcement of planning and environmental laws. So enforcement is a key issue. And we talked about that briefly. So I think at the start, Karen said, well, it may be that we're looking at prosecution of a company. What methodology do prosecutors use when pursuing companies or those accused of environmental damage or harm? What type of techniques can they use? And I'm sorry, that's a big they, but what type of enforcement? Yes, David.
They could basically do environmental impact assessments,
yes,
and use those to evaluate basically what sort of has occurred within regards to whatever case they're looking into.
Okay, so some sort of assessment to determine what's happened. Any other thoughts on what regulatory bodies, if I could use the term very broadly, have the ability to do to deal with environmental wrongdoing?
Yeah.
Yes, Emily?
So your local government environmental health officers and also your Department of Environment and Science officers have the authority to investigate and prosecute matters, depending on what level it is.
All right. So you've mentioned their local council tier and state government tier and the ability to investigate, which is fine, it's good, and also to prosecute. What do we mean by prosecute? When you think about the word prosecute, what does that mean to you?
Commencing a court action for an offence under the relevant legislation.
Correct. Criminal or civil? Or could it be both?
Could be both.
Could be both, exactly. All right, so, and in terms of other things that may crop up in the exam, Emma says planning departments, disaster management units of councils, and others that may have an interest. So when you're reading your material, I'd like you to think about the material in a proactive sense and think about why did this case get to court? Who prosecuted the case? What was their standing? What was their right entitlement to be there? Was it common law based, or more likely was based on statute? And if so, what statute? And apart from what appears in the case as the enforcement proceeding or prosecution, did that authority, that regulated authority, have any alternatives? Indeed, were those alternatives exhausted? So as you're reading through a case, let's say it might be a criminal law prosecution, there might be some reference to the attempts that were made by the regulatory body to resolve the matter short of criminal prosecution, which is generally regarded as a last resort. So if your task is to provide ambit advice to, for example, a council as to what the council might do, you need to think laterally and broadly about various options that might be available. Or if your advice is to a group of community litigants that are upset about, a smelter project which is proposed in the adjoining suburb, then what entitlements do they have to be in court? Is court the only option, etc.? So think broadly and consider the material from a broad.
Are you talking in? Sorry, John, are you talking in relation to alternative dispute resolution before it gets to a court action?
Could be. ADR is very important in environmental law. That's one of the options, yes. And it may be that it's court ordered, or it may be that it's something which is undertaken by the parties on a voluntary basis. So, and that all of these things relate to different entities and different protagonists or antagonists, as I said. So your task is to try to catalogue those things now so that you've got this almost like a flow chart of or options list or checklist to say, okay, for this type of litigant or this type of person affected by environmental law, here are the options, here is their standing, here is what they could seek. It may be that, and I think it was Jamie Lee said, well, they might have the power to investigate. Do they need to have the ability to access some of the civil law procedures, such as Morava injunction and Anton Pillar orders, that might assist in environmental law as well? So thinking broadly and thinking about it from different perspectives is really what I'm keen to have you do at this stage. Now, I mentioned the textbooks, the textbook and the supplementary just briefly. There are some other excellent resource materials, but I'm conscious of the fact that you have a great quantity of material to read already by reference to the textbooks. But if there was another one that I would urge you to consider, if you want to borrow this from the library, perhaps if it's available, or generally, it's this one here of Fisher. And Fisher's textbook is excellent. So that is Australian Environmental Law Norms, Principles and Rules by Fisher. It's a Thomson Reuters publication. It's an excellent text, and it's in a style that's similar to our prescribed text, but it looks at environmental law from a slightly different perspective. So that's Fisher. There's another good one, Understanding Sustainability Law, which is a very good text. And then a couple of really simple ones, a tiny pocketbook, Nutshell, by Rachel Baird, which is a short book providing excellent commentary and information about environmental law on the run. And Brad Jessup has another excellent little short book, Environmental Law, LexisNexis. It's short, but it's directly on point, excellent resource. It provides some case law material. So they're some of the other textbooks that you might consider as useful. And one final one, this is out of date. I haven't got the up-to-date one yet, but the excellent Community Litigants Handbook, published by the Environmental Defenders Office, and the editor is on this publication at least was Anita O'Hart, and that publication provides direct information relating to proceedings in the Planning and Environment Court. So the Community Litigants Handbook through the Environmental Defenders Office. And if you're looking at the material that I've pre-recorded on Moodle, you'll see that there's an excellent interview with one of the solicitors from the Environmental Defenders Office for you to consider. Obviously, at this stage, I expect that you all know how to access case law and legislation. If you have any problems, please let us know. There are OSLE people, there are Federal Register of Legislation people, the Legislation Register, and those of you that would like Barnett Jade or courts' websites. The courts have excellent material in relation to environmental law. If you don't know how to access legislation, case law, and other materials through those databases, then please let us know. I'm sure we'll all be happy to help if you're struggling. But would I be correct in assuming we all know our way around legal research? Yes? All right. If you like, I did prepare some legal research videos 18 months, 2 years ago, and they're still pretty useful, and I think they're on Moodle, so you'll see those under additional resources. When you're presenting your material, please, Australian Guide to Legal Citation version 4. If you don't have reference to or access to so the Australian AGLC number 4, please do so and follow those rules. All good? We all know how to cite and footnote reference material. I really don't want to be saying something like, you know, superscript should follow, not precede, punctuation. I get a bit tired of all those sort of comments, but we don't need to worry about that, do we? We're on top of it. All right, good. So in environmental law, the focus is really based on statutes. Could anyone tell me why I make the comment that the focus of environmental law is statute-based as opposed to common law-based? Any thoughts? I mean, it is what it is, isn't it? Yes, Jamie Lee.
Just going to say the grounds of environmental law are quite well set out in the legislation, not so much in common law. So, I mean, yeah, it is legislation. That's why it's statute-based.
That's where it is, yes. So when we're thinking about environmental law, predominantly we're thinking about legislation. Historically, there's a specific reason for that. I'm also taking Contract B this term, and last night, those of you that were doing Contract B would have been online with me, and you'll know that the common law essentially developed the rules of contract, and legislation has not largely interfered with that, with the exception of the Australian consumer law and consumer legislation generally. But it's still, for contract law, it's still very much common law based. Environmental law, litigation based. Sarah, I like your response. You say because the common law dealt with the environment in a way that was focused on the protection of individual property owners' rights. There was no such thing in the common law as the big picture. There was no such thing as protecting the environment for the benefit of all of us. A dispute went to a common law court in relation to an environmental issue and was looked at from the perspective of property rights, or perhaps contract, or more typically, torts law. Did the actions of a landowner in developing an open-cut coal mine have an effect in negligence or nuisance on the neighbour? The broader issue that the environment was suffering as a result of this activity was not part of the common law. So the protection of the environment for its own sake, says Sarah, was not part of it, and therefore legislation was required to overrule the effect of the common law to provide this bigger picture. But where was the, generally speaking, this legislation comes as a result of international law and international treaties and international obligations. So in environmental law, more than probably any other area of law that I can consider, it filters down from the international level to the national, to the state, to the local council in the form of international treaties, obligations and commitments, then into legislation, and then into regulations and bylaws at the lowest level of the local council role. So you'll see a lot of the principles filter down. Can anyone identify some of the basic principles of environmental law that we see at all levels to some degree or other? Any basic principles of environmental law?
Are you speaking about specific sort of international acts or?
No, not specific acts, but more concepts and aspirational type matters. There's a few key phrases.
Things like
Yes, Jamie?
things like environmental harm.
Yes, very good. Environmental harm. So when you see these sorts of things, ecologically sustainable development, principles in relation to intergenerational equity, things of that nature, you'll see these are catchphrases, and these are principles that have been filtering down from, say, the Kyoto Protocol into the, let's say, the Environment Protection and Biodiversity Conservation Act at the Commonwealth level, or the Environment Protection Act in Queensland level, and the same sort of principles come through. So as you're reading, try to identify those things that appear to be important environmental law principles, because you want to focus on those and certainly include them in your assessment work and your examination work. And of course, understand them so that if you're arguing an environmental law case, you can rely upon these general principles and philosophies. Very important one that you really must look at carefully from day one is the precautionary principle. Has anyone come across the precautionary principle? If not, please, that's part of your homework this week. So that's what I'm really getting at. Also, understand the key pieces of legislation at a Commonwealth level. I've mentioned it just now, the Environment Protection and Biodiversity Conservation Act, 1999. That's quite possibly the last time that I'll refer to that legislation in its full form in this unit. From now on, if I talk about the ECPPA, you'll know what I mean. EPBCA, yes, you'll know what I mean. So also at a Queensland level, we have the Planning Act and the Planning and Environment Court Act. We have the Environment Protection Act, then other pieces of legislation such as the Vegetation Management Act, Nature Conservation Act, and the State Development and Public Works Organisation Act. Now, some of these, the full one was the Environment Protection and Biodiversity Conservation Act, the EPBCA, 1999, that's Commonwealth. Some of these acts you'll see are repealed from time to time and change names, even though it's essentially the same thing. So the Planning Act, Queensland, was previously the Sustainable Planning Act. Prior to that, it was the Integrated Planning Act. Prior to that, it was the Local Government Act. So a lot of the principles follow on, even though the legislation changed. Oh, Jamie Lee's firing away here. He's got the EPBCA Act, Sustainable Planning Act, which followed on from the Sustainable Planning Act, planning regulations, the Planning and Environment Court, and that's from Week 1 Study Guide. Okay. And again, just watch out for those things that do change and they're repealed, replaced, as it were. When you're considering the material, you need to consider the courts and jurisdictions generally of matters involving the resolution of environmental law disputes. So importantly, the Planning and Environment Court in Queensland. But not all environmental law litigation is dealt with in the P&E Court. Apart from the Planning and Environment Court, you need to be mindful of the jurisdiction of, let's say, the Land Court or the Magistrates Court, which deals with some criminal law matters as well. But understand to some degree the role and the jurisdiction of these various courts. I asked this question last night, I'll ask it again tonight. Can anyone tell me what I mean by the term jurisdiction? You see it a lot in law, don't you? What does jurisdiction actually mean?
Whether it's the appropriate court to take the matter to.
Exactly. Very good. It means essentially, does this court have the legal authority to deal with the matter before it? Does it have jurisdiction? Sarah says the authority that applies to the case. Very good. So it's important that you understand that, because if you go to the Planning and Environment Court or you give advice as part of your take-home paper to somebody to take the matter to the Planning and Environment Court, you need to know a few basic things, don't you? You need to know whether this is a state or federal matter, because if it's a federal matter, then maybe you don't take the matter to the state-based Planning and Environment Court. So we need to understand the distinctions and think about, well, what is the federal court that deals with these issues? Pretty much given the answer there. If you do, for example, take a matter to the P&E Court, so when I talk about the P&E Court, I'm talking about the Planning and Environment Court. So if you take a matter to the P&E Court, what power does the court have? For example, does the court have power to make declarations, to order injunctions? Does it have the power to overrule development applications and approvals that have been granted by councils? If so, what is the basis upon which the court generally acts? So if, for example, you're involved in acting for a property developer that wants to have a shopping centre built, and the council says no, understand the basic reasons why the council might say no, and understand what it is that you can do to convince a court that they should overrule the decision of the council. So an important concept which comes into the planning law aspect here, which is always relevant, is what do the planning schemes say? And does the proposed development conflict with the planning scheme? or otherwise, is it consistent with the planning scheme? Then as you're reading cases, you'll see some other catchwords, some other reasons that courts have either approved certain things or rejected other things. For example, does the proposed development have an adverse impact on the environment? So these are all things that you can consider. And when you're considering the role of the court, think about the court's role generally in terms of providing declarations and decisions about matters as against its enforcement function. So it's one thing for a court to say, here's what we're going to do, but then what if things go wrong? Where do you enforce these orders? Who has the power to enforce the order? An example is in Fraser Coast Regional Council against Byrne Brothers. It's a Planning and Environment Court decision from 2013. The reason I'm mentioning this is that I think that was the decision that formed the basis of the take-home paper 2 years ago. There was some issues around the council seeking to enforce an order pursuant to the now repealed Sustainable Planning Act. So the point is not so much that specific case, but again, to follow on what I've mentioned earlier, as you're reading the material, think about how did we get to this stage? What's the authority, what's the jurisdiction of the parties to be at the court? What's the jurisdiction of the court to grant the order? What are the range of orders that are available to the court? And what's the legislation? Typically the legislation that backs it up. Correct me if I'm wrong, but in the first assessment, do I ask you to prepare possible grounds of appeal on a decision? I do that often. Has anyone read the first assessment? And I have done that?
I think
Okay.
it said prepare a case note and an appeal document.
Yes.
I haven't got it in front of me, but yeah.
Yeah. So usually the layout of that type of question is, you know, easy, 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 and then really tough. The really tough is the hypothetical appeal. So the idea of the appeal, what I'm asking you to do there for that first assessment is look at the decision and not just describe it, not give me just a case note, although that's part of it, but to read proactively and think, well, if you were to advise the party that lost, what's some argument you could come up with that will convince a court, the right court, to overturn the decision on an appeal? Jamie Lee, looks like you've got an inside advantage here. Hypothetical appeals your problem child every day. So, wow, anything you want to share there about what you need to do when considering a hypothetical appeal? You don't have to, but it's an interesting area. So what I'm looking for there is for you to be inventive and also critical in a nice sense, not in a dismissive or condescending sense, but critical in the sense of saying, all right, well, this is how the judge interpreted this provision and applied it in these facts. But is that the only way that the court could have approached this? Is there a different way of looking at it? Should the court have come to a different conclusion? Was there some other piece of legislation or regulatory material that would have changed the situation for the court? So, yes, looking at hypothetical appeals is a different way of looking at things. So courts that deal with environmental law matters, I mentioned the Land Court, the Magistrates Court, also the Development Tribunal, which deals with certain disputes. So try to understand and gain develop a flowchart, for example, in relation to these different areas. Because we're dealing with statutes often, that means that you need to also consider regulations. And because we're dealing with courts and tribunals, you need to consider other documents that have a very important practical effect on the way you go about business within that sphere. I'm being very vague here, but I've mentioned legislation, regulations. When it comes to dealing with court practice, what other types of documents do you need to consider? Very vague question. Court rules, says Kathleen. That's very good. Any others? Practice directions. Thank you, Nadine. All right, so refer to court rules, refer to practice directions. If you have difficulty in finding those things, please let us know and we'll see if we can find them together. And I'll refer you to some of those as we proceed through the unit as well. Because we're dealing with legislation, primarily in environmental law, that means that you'll need to dust off the textbooks on statutory interpretation and be prepared to use them. So some of the principles, Project Blue Sky is always a good case to cite if you're advancing an argument in environmental law, because it's the leading case that deals with statutory interpretation. So don't ignore the possible effect of provisions in the Acts Interpretation Act, for example, if you're promoting a certain argument. It also means that you need to consider things like the second reading speeches and explanatory notes or explanatory memorandums. Now, Jamie Lee said also consider the specific court rules that might apply in different courts and jurisdictions. So, for example, we have generally the Uniform Civil Procedure Rules, the UCPR, but you need to apply those where possible in conjunction with specific rules such as the Planning and Environment Court rules and the Planning and Environment Court practice directions. So thank you, Jamie Lee, for that. If you don't know how to access second reading speeches and explanatory notes or explanatory memorandums, then you'll need to do that now. At a common author level, is it an explanatory note or an explanatory memorandum? What's your vote? Common author, is it note or memorandum? Bit of trivia, really, it doesn't matter much. Lois, Nicole, very quick off the mark, correctly identified its memorandum. When we're dealing with the Queensland sphere, we talk about explanatory notes. Really the same thing, just different terminology. Now, each week I'd like you to have a go at the problems that are on Moodle, and if you could upload your answers, that would be most appreciated. So I'm just going to take a punt. I haven't looked yet to see if there are any answers. No, there's no questions this week. Well, that was handy. So have a look through the problems and do answer those as we proceed. All right, so that's just about all that I wanted to cover tonight. It was really just a broad introduction to environmental law. And you'll notice for the first 3 weeks, it's chapter 1 reading. Part of the reason for that is that the 3 introductory chapters, as they were in textbook, in the 9th edition, have been consolidated. So it's really just a much larger chapter, but the content is basically the same as the 3 chapters as they were in the 9th edition. But there's a lot there to cover, and it's important to understand the basics. All right, before we wrap up for tonight, are there any questions that you want to consider? Any comments? Are we all good? All right. Well, thank you very much. I'll see you all next week, 7 p.m, and thanks for joining us. Bye then.